Good evening. Welcome to our live webinar, Family Law Q&A, where I deal with various questions that are being posed by you, either previously or live via our various platforms. If you are watching this video live, please note you can pose questions, or you may pose questions via the Advocate Muhammad Abduroaf Trust Account Advocate Facebook page. And if you are making use of that platform, please pose a question and I will obviously be happy to engage with you. But today's topic, not necessarily a topic, but something which I felt is very important to address, not only to people who have child custody, access and guardianship issues, but also legal practitioners. Some attorneys or advocates might find it useful as well. It deals with how do you engage with a client the first time when it relates to a child custody, access, guardianship matter, relocation, and so on? Or at the same time, if you are someone who has certain issues or certain problems regarding access contact, either the father or the mother or the grandmother or the aunt, etc., there are quite a few questions which you want to, think about or apply your mind to, and from there unpack matters, unpack things in order for you to have a better understanding regarding your specific problem. So I have seen it in the past where certain individuals draft their own legal documents, which they are entitled to do, and I'm happy if they do that, and they submit a document that's literally 2 pages long, and they expect to be successful in a full-blown custody battle, a guardianship application, matter, etc., because they believe these are the only information I need to, submit and outline in my documentation. So, if you are that person or you would like to learn a bit more regarding the specific issue, please watch this video till the end. So, the way I generally deal with these type of matters are when a client approaches me with a specific legal problem, I'll listen to the client and try to determine, can I assist him or her? Is it viable to go to court? Because not all matters need to go to court. Sometimes you just have to write a letter, and that should generally fix the problem, or advise the client or direct the client. But when it comes to certain legal problems where you see litigation is required, you do not want to sit with a client for 5, 6 hours asking the client, what's your name? Okay, you'll ask the name, of course, your ID number, your date of birth, where do you stand, all these things in your consultation or in your office. Spend a few hours obtaining this information, which could have been done differently. You could have sent the client a questionnaire after your consultation, after your hour consultation, after you, and obviously your hour consultation or your initial consultation is necessary because then you'll explain to the client your processes, how things work, advise them a bit, and analyze the case to a certain extent, but not necessarily sit down with them and ask them a million and one questions. They might be very nervous, they might not have the answers at hand, they might guess, or they might be overwhelmed because they are sitting with an attorney or an advocate. Therefore, in the arsenal of any legal practitioner, attorney, advocate, etc., they should have some questionnaires available very quickly to send to the client as soon as possible. So I pulled out one of my questionnaires, and I hope that you, if you are an attorney or advocate, you have your own questionnaire, and hopefully, more than likely, it should be more or less the same which I have. But if you are a layperson, a non-lawyer, and you are dealing with these type of things, just have a look at this questionnaire and apply it to your specific scenario. So let us begin with the questionnaire. Okay, this is obviously you can see the top says questionnaire. My details: Advocate Muhammad Abduroaf, and I'm an advocate of the High Court of South Africa. Now, this questionnaire, of course, is in Word format, and that's the format I send it to the client because I would like the client to mess this document up, not mess it up, but type as much as they want. Give me as much data as possible. I read extremely fast. I can absorb information very quickly because I deal with these type of matters on a regular basis. I'm certain if you have to give me a document regarding quantum physics or maybe an architectural document or something else that might take very long to read. But legal documents are quite good at that because I understand the nature of the matters, family laws, custody issues regarding that. So it's easy to follow. But nonetheless, the client will first advise me if it's a child custody matter or guardianship matter, whatever the case may be. So that's here at the bottom. So I will have an understanding of the specific issue or the specific matter when I look at this document. Okay, today we're dealing with a relocation matter. So my school of thought or my way of thinking will be around that. This question here, of course, is here phase one. Now, the reason why I say phase one is because there may be a phase two. This is the information which the client is providing me with. He or she might think certain information is relevant, might think certain information is not relevant. So based upon all this information I obtain, I might pick up other questions that I might want to ask, which might be extremely relevant, but the client did not elaborate on it because the client believed it's not relevant. But at the same time, the client might provide me with a wealth of information that is not necessarily relevant to the specific application. For example, in a divorce matter, she's speaking about the client wasting his money on certain type of business dealings, but the parties are married out of common property without the accrual system. So that wasting of his money is not really applicable to the specific case because in any event, she would not have received any of that money of the defendant or her husband, whoever the party is. So that information is irrelevant. Or she deals with a lot of information regarding the abuse she has suffered from the specific party, but her application relates to an application to obtain a passport to visit with a minor children, her family overseas. So whether or not he did abuse or did not abuse, it does not make a case stronger or weaker in an application for the minor child to obtain a passport. I cannot see how that would assist her. So she might focus a lot on that specific aspect, or he might focus on the aspect that she had an affair, the wife had an affair for argument's sake. But here we're dealing with something totally different. Here we're dealing with a division of the joint estate. Having an affair could potentially be relevant, but not always so, unless you're arguing forfeiture of benefits. But each case is different, so that's where I'm going to. This is phase one, whereby you'll give me more than likely 90 or 80% of the information I require very quickly, very swiftly, in the comfort of your own home. You can draft this document, it is in a Word format, and you'll just type and type and type and provide me with data. If I had to do this in a consultation with you, I would have asked you the question, you would have thought about it, I had to write it down on pen or dictaphone. It can take so long, and a lot of information will be lost, and there might have to be a phase 4 or 5 as well. So I mentioned specifically here, when answering below, please use a different color or type font if possible, so I can see what's yours and what was ours. We can do it without that, but it makes it a bit more easier. So type as much as needed. I specifically state that. You may add questions, columns, sections, etc. And I say this is your document to work with. It's not my document, it's your document. I'm just giving you a template to work from. So that's very important. Okay, so the first thing you will, or maybe not the first thing, but at the top you'll provide me with this issue, the legal problem. Give some background information of the legal problem you have. So here you can type and type and type and type. You see where I'm going to where that is concerned. It's a Word document and you can obviously go as deep as possible, as much as you want to. Now I'll have a bigger picture. Okay, here we're dealing with issue concerning custody. The father is refusing the contact with a minor child. She might mention that the parties were married, that they are now separated, but now she remarried and now the father does not want her to have contact. So I'll get some background information regarding that. Okay, so I pick that up. I'm starting to, let my brain do some working. Then let's go further. Details of parents or parties, very important. I would require certain information, names and surnames of the parties, and I will not spend much time in my initial consultation obtaining all this information. Maybe it's their name, surname, telephone number, but more than likely they would have provided that to us when making an appointment initially via our online platforms. Then the father, applicant, respondent, or other. Various aspects can apply here. This matter could have already been in court in the sense of a party could have been served with court documents already. it's possible, and they approach me after that. So this form is still workable where that is concerned. They can still provide me some relevant information where they're concerned. Okay, this is my details, a trust account advocate. So I'm a trust account advocate, meaning I can obtain instructions directly from the public. So moving forward, ID number, etc. from the other party. So that's fine. So in children matters, so in family law matters, most of the time, other than a divorce issue or some other legal problems the parties may have, there are always children involved. So I'll require the details of the children. This should generally be enough: name, surname, ID, age, place of birth, home address, school, extracurricular activities, medical condition, or history, other relevant matters. If there is a second child, what you do is you, sorry, I'm copying this way too fast. You copy and paste. You copy this, and then you just paste it below for child number 2. So there you see it. So there's like 2 kids now. And child number 3 or child number 4, we just do that. So that took it out again. Now, this is where the wealth of information will be obtained, the background of the parties involved. Very important for me to have some insight. Were they married? Were they in the relationship only? Are they separated? Were they divorced? Place of separation and relevant information. Sometimes these questions might not make sense specifically to a specific client, but to a different client, it might make a lot of sense. So if it doesn't make sense, you know what to do? Change that. Place of separation. Say when you were separated, or add your own question, or add your own comment. Play around with colors. Give me the data as much as you can. Is there a current court order in place, like, for example, a divorce order, a parental responsibilities and rights agreement? This could be an application where the grandmother would like to have contact with a minor child. That's also possible. Or an uncle. This is the possibilities are diverse, not necessarily mom and dad only. If there are court orders in place, please provide it to me. Any other relevant information, my apologies, you provide that to me. So I will obviously look at that. I understand this form, so I know how this form works. So when I see additional typing, I know that is data which you have provided me with. Childcare and relationships, some background information here as well. If you are the father, were you present during the child's birth? Yes. If not, was he present? Because then the mother will be answering that question. Was the father present during the medical checkups and vaccination of the child or children? Yes, no, you'll understand. If you are the father, you'll say yes. If you're not the father, mother will say yes, he was, or yes, no, he was not. Who took the children to school before the need for this application? Some background information. There could have been some issues regarding that. Who collected the children? Who takes them to school, fetches them from school now? Assists the child with homework, who attends to parent-teacher meetings, who attend to the minor child when returning from school, etc. Meals, chores, birthday parties, daycare, sitters, medical conditions. Are there any medical conditions regarding the other party or any other parties, etc.? Does the child or children receive any religious training? If yes, from whom? Do they go to Sunday school? Do they go to Madrasa? Do they go to the synagogue? Do they go to the temple? All those things it might be relevant because this case might revolve around that. That's where I'm going to. It might be an issue where the children were brought up in a certain religion and now one party changed the religion and now another parent might have an issue with that and believe, no, it's not a good idea. The case might be harping around that specific aspect. I do not know. We put it in there. If you don't answer the question, it's not applicable to you, you just leave it out and we move on. Mediation. Have the parties tried to mediate this matter? Are you interested in going to mediation if it has not taken place, and so on? Then urgency. More than likely, this would be a matter where I would have to take it to court. Most probably send the other party a letter first, demanding that compliance be made with whatever is required, either allow contact, etc. However, if that cannot be resolved in that specific fashion, or the matter might be so urgent, I need to take it to court immediately, not even try to WhatsApp the other party or phone the other party. So you have to explain urgency. Each case is different, each scenario is different. Is a plane leaving tomorrow? Has the other party agreed to the minor child visiting the United States with the mother, but all of a sudden consent is now removed, but the plane is leaving in 2 days' time? This matter is extremely urgent. The passports are there, the tickets have been paid, here all of a sudden consent has been revoked. That's an extremely urgent matter. Or must a child be enrolled into a school in 2023? We have some time. So it's not that super urgent, but we need to resolve it here in the next few months' time for the latest. Or we require an answer by next month, makes it much more urgent, and so on. What type of relief do you want from the court? I leave that to you initially. You can be creative and you can tell me, I want the court to do that, I want the court to do that. I want the court to grant me contact, I want the court to limit the other party's contact, I want the court to give consent for a passport or for relocation overseas, I want the court to give me sole guardianship rights over the minor child, I want the court to allow the minor child to be enrolled into a specific school. And documentation, I say the following. Kindly provide copies of birth certificates, identity documents, and passports of all parties in your possession. So if you have it in your possession, if you do not have any possession, that's fine, perfectly fine. And remember, this is phase one. A lot of data won't be here. And if, for example, you provided me with none of this documentation, I might in phase two ask you for ID numbers and so on. But more than that, I presume you will provide me with that information, provide in the next section other relevant information, provide as much information as possible. Then, very importantly, please note that the above information is only a guide and you need to elaborate fully and as much as possible for us to draw very good papers if need be. If you feel something is relevant, please mention it. We need the entire history and picture to present to the court and for our understanding. Therefore, provide us with as much historical information and other information regarding the past and the relocation as possible. I put that in, especially for us to say if you are dealing with a relocation matter, even if it is not mentioned above. This is very important. And then that's it. That's all be phase one. Phase one. Quickly, after my consultation, I send this to you. You would have worked through it, you would have completed it, and sent it back to me. I have my notes of my initial consultation with you. I obviously now have additional information. I know what I need to do. I know what is required from me. This is now a application for relocation. I know it. That's done. Now I need to start drafting, but I require certain information. I do not know what school you intend to enroll the minor child in Germany, for argument's sake. I do not know what address is. I do not know how the minor child's grades are in South Africa, which might all be very relevant, and therefore I require that information. But that will be in phase two, and it will save so much time. So we had an initial consultation for an hour for me to understand, explain the process to you. Now we have a questionnaire where you provide me with relevant information, and I will send you another questionnaire applying mine to maybe spend an hour on that as well. The finer details of what is required, you send that back to me. You spend was probably 3-4 hours on that, but it's not time spent in my office, so you save a lot of money there as well. And then I'm ready to proceed drafting your application. That's how simple and easy it is. I see I have a question online. Let me just deal with that. Seeing that I have now completed the questionnaire part of it. Thank you very much for that. It goes as follows. Good evening. I hope this question is relevant to the topic. My ex has filed for maintenance for our child. I was unable to make the appearance on Wednesday due to a death in my family. We have already swapped bundles of documents. This lawyer emailed me directly advising I have been subpoenaed to provide my 6-month bank statement, etc. Proof of unemployment, etc. Do I provide this? As there was no subpoena attached, and all of this was already given to to the maintenance officer and my ex. It's a very difficult one because the lawyer is saying one thing that you have been subpoenaed, but and you said you already swapped this documentation. But in all honesty, this is my motto on these type of matters here. I can tell you, if you've done it, do not provide it. But if you have provided already, just send it back to these attorneys. These are attorneys, and some of them um, believe they are right, or some of them believe that they are doing things the way it should be done. The best way to resolve these matters are if they requested the specific documentation and you say you have provided it to them, just rescan it in and send it back to them to avoid any hassle from happening in the future. It is a maintenance matter, and my motto in all maintenance matters are whether or not you are my client or for the other party, the father or the mother, depending on who I'm representing, provide as much information as required. It is a child matter. It is a matter whereby the court can only make a proper decision if the court has full and frank disclosure from all the parties in the specific matter. How can the court determine how much should be paid or how much should be spent or what the needs of the minor child is, etc., unless both parents outlines and provides all the relevant information to the court. So I do not want to guess here and say, yes, maybe the subpoena was sent, maybe the subpoena was not sent. I'm going to an arena which I have not have any knowledge of or factual information or knowledge about. So my advice to you is provide this information to them, maybe again, scan and email it to them. You have proof of that you have done that. So when you do approach the court the next time, the court will obviously have proof in front of them that you have sent the documentation to his attorney, and this matter can proceed accordingly. I hope that answers your question. If I have not answered the question correctly or adequately, please send another comment. But I think this video is now basically done, and I hope that you have benefited from it. I see no further comments. Thank you very much for your time, and I hope you have a wonderful weekend. And I'll see you online next week. Thank you.